U.S. Supreme Court just issued a ruling in a major redistricting case. The justices struck down Louisiana's new map. Let's start with CBS News legal reporter Katrina Kaufman. Katrina, thank you so much for joining us. Break down this ruling.
So what the Supreme Court has decided is that this congressional map that was created in Louisiana to create a second black majority minority district is an unconstitutional racial gerrymander. I've been looking closely at the very strong dissent written by Justice Elena Kagan. It's actually, I think, even longer than the opinion itself. And she talks about how this is essentially eviscerating the Voting Rights Act, even though they don't outright overturn Section 2 of the Voting Rights Act, which was a concern that could be a consequence of this ruling. She said that basically, they are rendering it null. She talks about how the Voting Rights Act was born of the literal blood of Union soldiers and civil rights marchers. And she said that today's decision renders it all but a dead letter. So this could have a significant impact on minority representation in politics.
Stand by, Katrina. I want to bring in CBS News legal contributor and professor at Loyola Law School, Jessica Levinson, and we're also going to be joined at some point by Jan Crawford in Washington. But Jessica, let me begin with you. So how realistic is the court's demand that plaintiffs disentangle race from politics, given how closely those seem to overlap in American voting patterns?
Vlad, you've hit it. So this has always been difficult to try and say, how can we separate out politics and race when sometimes, frankly, we see race as a proxy for politics and vice versa. I think what we have here is a court saying something that it's consistently said for years when it comes to other cases in other areas. Let's think back, Vlad, to affirmative action, which is don't use race. So what we have in this case, when it comes to we're talking about drawing legislative district lines and what you can consider when you draw those lines, and specifically in this case, what you can consider when you draw those lines to comply with that landmark piece of civil rights legislation, the 1965 Voting Rights Act. The court is saying, do not consider race as a dominant factor. What does that mean? It means that if we go to court and we challenge lines, that what the state can say is, I wasn't considering race, I was considering politics. And I think that that would be a very strong defense after this particular decision. Now, Vlad, I don't know that I'm answering your question because, frankly, I don't know that there is a true answer to how do you ever separate those two things completely versus what's going to happen in court moving forward. That I think I can't answer.
Well, that's the point that the dissent makes, right? The dissent is essentially saying that the majority is ignoring what are real world discrimination where race and politics are often intertwined, and it's very, very hard to separate. Even the notion that we say, as we report this, that this is now going to benefit Republicans, which would lead to the assumption that it's mostly white Americans who are in the Republican Party and not black Americans.
Well, that's right. So obviously we do have, it's not just assumptions, but we have data where you're looking at certain groups and certain minority groups, and you say this group tends to vote more for this party. Now, of course, we should be careful about this because, as we've seen for the last number of elections, some of those assumptions can change, and it depends on what's happening in the country. It depends on the candidate. But certainly it has been for years the case that if you look at a certain group, you say they tend to vote Republican. If you look at another group, you say they tend to vote for Democrats. What the court is saying here, what a majority of the court is saying is, you can consider things like political affiliation. You can consider the traditional factors that we use when we are drawing lines, but do not use race as the predominant factor. This feels very similar, Vlad, frankly, to the conversation we had after the affirmative action decision. You can consider other ways to make sure that you have this kind of college classes that you want, but don't consider race as a factor.
Let's turn now to CBS News chief legal correspondent Jan Crawford. So, Jan, the goal of this second district in Louisiana, which was majority black, was to create more representation in voting there. The Voting Rights Act prohibits any kind of racial discrimination in voting. How then is that district, based on this order, in violation of the Voting Rights Act?
They're saying that just because you say you have to redraw this district or draw this district under the Voting Rights Act, it doesn't mean that you can violate the Constitution. And I think that's kind of the big underpinnings of this decision. Obviously, this is kind of an interesting case because Louisiana initially just had one majority black district. A group of black voters sued. They took it to court and they won. And the court ordered the state of Louisiana to draw that second district to comply with the Voting Rights Act. Then what happens? Well, we're a litigious society. Another group of voters, mainly white voters, sued, saying that second district was a racial gerrymander because it too closely focused on race and the race of the voters, and that violates the Constitution. So that was the case that was before the court today, and that's when they struck down today that second legislative district as violating the Constitution. The argument was that complying with Section 2 of the Voting Rights Act was enough of a compelling interest to justify considering race that would otherwise be unconstitutional. And the justices rejected that argument today. They're going to make it much more difficult, I think, for legislatures now to really just focus on race and draw those. You showed the district earlier, these kind of districts that zigzag across the state, picking up black voters in completely different cities and potentially communities of interest to get that district that has enough black voters to make a majority. In the short term, I mean, there are 61, I believe, the last I checked, black representatives in Congress right now in the House, and 15, I think there are 15 now majority districts. So it's not going to have, a dramatic impact on representation. I think there's about lawyers on both sides that I've talked to. There's about 12 districts right now where you may see some challenges. But keep in mind, Republicans like these districts. They like majority black districts, too, because they like having, enough voters in their district where they're not as worried about getting reelected. So, it can kind of cut both ways. I don't think we should assume that all of these majority districts are going to be challenged now, or that it's going to have this huge dramatic impact on black representation going forward. The writing has been on the wall for this. There was an important case in 2024. If you look at what Texas did with its redistricting, they didn't even really mount serious Section 2 challenges. So, when you see states going forward talking about redistricting, like Florida, for example, trying to redo its map, it will make it easier. They won't probably have to worry about Section 2 as much, but I think already state officials knew that this is the way the court was headed because they had a big case in 2024 that signaled this was coming.
Yeah, it's so fascinating to me, Jan and Jessica and Katrina, about how the Supreme Court has operated historically over the years, because I wonder how the court, in this interpretation of what they're calling vote dilution under Section 2, has evolved over time. The case that is mentioned is Thronberg versus Gingles, which is only, for those of us who were around, in 1986, which was, again, a landmark case. A unanimous court found the legacy of official discrimination. And it seems like the court is walking that back now. Do I understand that correctly?
I think I think the court is certainly saying we need to think about the way things are today. And as Jessica was saying, that's really how they approached the affirmative action case. And Justice Kavanaugh has talked about that, too. Is there some kind of limit, temporal limit? I mean, we're not in 1965 anymore. We don't have poll taxes. The numbers, if you look about participation and representation, are now in many states, even in the Deep South, we've gotten some kind of parity there and equity there. So they're saying it's time for us to stop focusing on race, as the Chief Justice said, going back now almost 20 years. So, yes, I mean, I think that this is a change. Obviously, they're not overturning that case that you referred to, although the state of Louisiana and others had certainly suggested that they should. Justice Alito, in his opinion, is saying that they're kind of updating it. Now, Justice Kagan, in her dissent, is calling him out for that. But, this is a decision that is very much in a continuous line of cases with this court on voting rights and certainly on other race discrimination discrimination issues. And the focus is the Constitution is colorblind. And we need to stop focusing and drawing lines based on race. That's something that Justice Thomas has been saying since he joined the court. And that is something now there's a majority of justices who agree with him. And that's why you have seen not only the ruling today, but the ruling 3 years ago in the affirmative action case when the justices threw out affirmative action in college admissions. This is a court that is going to continue saying no to racial preferences, no to race considerations, and insisting that the Constitution is colorblind. The liberal justices obviously do not see it that way.
Really quickly, Jessica, before we go, so do you think that it's fair to say that the Voting Rights Act is being narrowed, just narrowed by the court? They haven't struck it down. Or would you characterize these rulings as just clarifying the constitutional limits?
I think that entirely depends on your perspective. What the majority is saying here is we're clarifying what Congress could do when it passed the Voting Rights Act. So, Vlad, as you know, whenever the federal government acts, it has to point to part of the Constitution that gives it the power to do so. In this case, we're looking at the Constitution and we're looking at whether or not Congress had the power to say, under the Voting Rights Act, here's how you have to, for instance, draw district lines. What the court is saying is we want to clarify Congress would have exceeded its authority if it allowed for unconstitutional racial gerrymandering. And so I don't mean to try not to answer your question, Vlad, but I think this is entirely dependent on how you view the case and whether or not you think that the majority was correct or you're with the minority on this one.
Fascinating. Katrina Kaufman, Jessica Levinson, Jan Crawford. Always love a decision day with all three of you because I learned so much. Thank you, guys. Appreciate it.